going to be changing, and it's going to be called KW Cloud. So instead of going to various search engines, it's all going to be under one big cloud for you. There's KW Command, and you're going to have your own little Siri. It's going to be called Kelly. So it's going to be a lot of really good technology coming your way. They're estimating between August to December for all market centers to have this in their market center. So it's going to be cool, something to look forward to. Bring your business up to the next level. And wanted you guys to see this market report and how we are really rocking and rolling, even over last year. So if you can see, our closed units are up by 44.3% over last January. Our closed sales volume, this is just us. It's phenomenal growth here, guys, it is.
Get your share.
It's awesome.
$444 million in GCI. There's something wrong with that picture.
Closed GCI.
Oh, you have all of KW.
I told you.
This is all KW.
How did I have
That's
it?
that we are Trent.
That's a good part, but that's going to be a hell of a profit share.
Okay, so then, I don't know, I printed it out from something like this, and I've got the right
It's
one.
all back and
So let me
forth.
give you the accurate numbers.
Can't believe you
So
said that.
closed units are 44.3%, closed sales volume 38.4%, contracts written 33.3%, contracts written volume were up 24% over last January, and our closed gross commission income is up 37.4%. If you want this accurate one for our market center only to use, give me an email, I'll shoot it over to you. But you do have a copy of all of KW, which is also really something that you can show your sellers and your buyers. All right? Okay,
You
so
can do this report for yourself too. All I did was take it from our market center multi-year trends. If you've been in the business for more than 2 years, you have this information available, or if you've been with Keller Williams for more than 2 years, you have this information available to you that all you do is plug and play those numbers. It took me maybe 5 minutes to do, and imagine that leverage when you're out meeting with sellers and trying to get listings, so you can pop balloons.
yeah, there you go.
Forget
All
the
right.
making money, we were popping balloons.
Yeah, that's what's important, the balloon popping things. Okay, so I'm going to introduce to you now, again, Tom Gregory. He's our, attorney, and we do a lot of things with Tom. He has saved our butts a lot of times through the years. So welcome, Tom. Do you need my microphone?
I have a pretty big mouth.
I had a feeling you would say that you're an attorney.
She's taking a shot at me already? Wait, I'm not going to mention that I just saw an illegal lottery happen here. The state police are right down the road. This was a little bit of gambling going on. Not exactly the Catholic Church, and that wasn't bingo.
All right, Tom, I'm very sorry I said what I said.
Dad, maybe you can make yourself useful. And help me hand out some, yeah, sure, thanks. Anyway, Debbie asked me to come up to give you the benefit of my expert advice and opinion. And so the thing that I came to tell you was that as of 2 o'clock this afternoon, it's going to be 75 degrees every day until Memorial Day, and the sun's never going to go in. So your spring season is going to kick in early, sales will be up, this will be the best year you ever had.
We like you.
You believe that?
Yeah.
Why should you not believe that?
I believe everything.
Well, I saw 4 robins already.
Well, maybe, but I don't think that means a whole lot. Here's the reason why you shouldn't believe that. Because I'm not a weatherman. Not that you should really believe what the weathermen say, because they're get to be right half the time without any consequences. But the reason that you shouldn't believe it is because I'm not speaking to you from a standpoint of expertise. And if you take away anything from what I say to you this morning, it'll be that when you're out there doing your job, when you're representing buyers or sellers, or both, you have to be careful that you don't wear a hat that doesn't fit you. This little handout that I've passed out is sort of a distilled version of a longer presentation my partner and I often do, which is called Tips to Avoid Lawsuits, or at least tips to win them when you can't avoid them. No one can avoid them, no matter what you do. If you do everything perfectly, in this day and age, some disgruntled buyer is going to find a reason to blame you for his own improvident decision. You can't help that. And I just heard your sales numbers. Your volume is up a staggeringly high amount. The more transactions you do, the greater the risk that one or more of those transactions is going to wind up with somebody's feelings getting hurt and blaming you for it. So with greater transactions, at least in terms of numbers, comes the greater chance of a lawsuit. And what I always tell people in a situation like this is the same. If you listen to everything I say, if you take all my tips and you follow everything I suggest to you to the letter, I guarantee you'll never get sued. But I also guarantee you'll probably never sell property. So we have to ride the waves up and down. We have to be fair, but we don't have to give away the second floor of the plant. So let me give you my first tip of the day. Who knows, and maybe this will be a little bit small for some of you to see, but does anyone know who these fine-looking people are? They've been in the news. There are a couple of good-looking folks here. Anyone know who they are?
That's against the law.
All right, let me ask you another question designed to get you there. Raise your hand if you think it's a good idea to use your listed property as a place to have your extramarital affair.
You're not married, but doesn't seem like that.
These two geniuses are agents at another place I should not mention to you, Coldwell Banker, who had a listing in New Jersey, in Clifton, New Jersey, on behalf of a seller who had vacated his property but left it furnished. Unbeknownst to these two who worked on a team in more ways than one, he had outfitted, the seller that is, had outfitted the house with nanny cameras. And when he began to be disappointed that the property wasn't selling, because he, and think of the last time this has ever happened to you, the seller was complaining to the agents that he thought the listed price was too high. Okay?
That's a first.
Right. The place wasn't selling, of course, because the listing property was too high. The agents didn't want the place to sell because they were going there 3 or 4 afternoons a week and doing the thing. Okay? So they lost their listing, they lost their jobs, they've lost their licenses, and the worst part is the seller has all this film that he's put all over the internet. Okay? So,
Are they still together?
I'll have to follow through on that. I'm not too sure. On top of it all, they were both sued by the seller for a violation of their fiduciary duty to their client, of course. So there's my first tip of the day, or actually my second tip of the day. Don't pay any attention to me when I talk about the weather, and don't have an affair in your listed property. Actually, I'll give you 3 tips. Don't have an affair at all. Nothing good ever comes of it, or so I'm told. Anyway, Debbie and I were talking yesterday about what's significant in your business or what's significant in your life in terms of helping to protect you against the possibility that someone's going to come after you for something that they will allege you did that put them in the hot seat. And I mentioned to her that one of the things I often mention to real estate agents and brokers in this kind of setting is that you work in a very unique business in one significant respect. In your business, the contract that forms the very crux of the transaction must be in writing. You all know this from your experience and from your education in the real estate business, that an agreement of sale must be in writing and signed by the parties in order for it to have any value at all. There's not another business where that's true. If I contract with you to paint your house, we can have a handshake. If I contract with you to fix your car, we can do the same thing. If I contract with you to operate on your heart, I don't need a signed contract. But to buy a property, I need something in writing, because the law does not want to presume any facts that are not set in stone. So if the crux of your business is a contract that must be in writing, then you should make sure that every aspect of your transaction is in writing in some way. Which takes us to the first page of notes on this little handout here. Memorialize significant events. I often ask people, what's your biggest downfall, or what's your biggest enemy in this business, or what's your biggest potential trap? And people always say, well, it's the other agent, or it's a demanding seller, or it's the mortgage lender, or it's something or other. It's this. It's the greatest tool that has come along in the 21st century, but it's also the greatest danger. Because if you're like I am, you'll leave this meeting, you'll get in your car, you won't be 5 minutes down the road, and you will have made 2 phone calls, maybe 3. And in the course of the next couple of hours, you may make several more phone calls. Some of them might be to other agents, some of them might be to experts, some of them might be to mortgage lenders, some of them might be to your own clients. And information is exchanged, and you go home tonight and you forget all about it. And one of those phone calls you might have is with a buyer, rather, who says, you know what, I've decided I'm running a little short on cash, and my father-in-law looked at the property, and he's got a little bit of handyman experience. He says the property's in pretty good shape. I'm going to skip the home inspection. Against your advice, absolutely against your advice, he's skipping the home inspection. But when you say to him, when you say to that buyer, listen, I strenuously suggest that you get the home inspection, and he says, no, I've decided I'm not going to do it. If you let it alone, in a year and a half after he sued you, when he's not had a home inspection and says you told him not to have it, you don't have anything written down that calls him a liar. So, when I say contemporaneous notes, I mean even with respect to that phone call, something that you can print out, something that you can have in perpetuity that commemorates that phone call. So if you have that phone call with that buyer on the way home today, when you get home or when you come to the next traffic light, you tap out a message to them that says, hey, this will confirm that despite my most strenuous recommendation, you've told me you're going to disavow a home inspection. It's a bad idea, but I respect your wishes. And in a year and a half after he sued you and he says, you told me not to have it, you've got that piece of paper that says, oh no, here's the proof that I told you exactly the opposite. Spell out the 5 W's in your notes. The who, what, where, when, and why. So that when that note becomes the focus of some inquiry down the road, you'll have something to go back on. The more important, use less shorthand. Use real words. Say what you mean and mean what you say. But commemorate things in writing. There's no aspect of your transaction that's going to get you in trouble for having things in writing despite the fact that they're not required to be in writing. I've never seen a situation where an agent was sued successfully for having too much information. Consistency and regularity are key. If you can train yourself to every night retrace what you did that day and make a little note of it, whether it's in a text, because text can be reproduced now on print, or it's an email. If you can send an email to that other person that confirms what you've talked about, all the better. But you have something in writing. Because from my perspective, here's what happens. You get sued, and the case goes to the insurance company, and the insurance company sends it to me. We set up a meeting, and I tell you that at our meeting, I want you to have your transactional file. And this happens to me all the time. I walk into the meeting, the agent's there sitting at the table with a transactional file, and I know that this is a transaction that took 2 or 3 months. There were 2 or 3 addendums to the agreement of sale. There was a home inspection. There was a reply. There was a reply to the reply. It went back and forth. A lot of negotiations, so forth and so on. And I walk in, and the agent's file is this thick. And I think to myself, oh, crap. Because this is going to be a reconstruction from memory, and that's always a bad thing. On the other hand, sometimes I walk in, and the agent's sitting in front of me with a file that's as thick as the phone book, and she's embarrassed because she's got so much. And I'm saying, you have no idea how helpful this is. If there's a note in there on a matchbook cover, on a cocktail napkin, on the back of a sandwich bag, I don't care what it is. If it's a note that commemorates something that happened in real time, that's going to help you down the road. Because when you get sued in one of these transactions, you're going to be sued likely under a couple of different claims, legal theories. The first is negligence, that you did a lousy job, that you were careless, you didn't make sure that your client's interests were adequately protected, and for that claim, the statute of limitations, that is the time within which that party must sue you, is 2 years. Okay, so it's February 22nd, 2017. So you could be sued today under a theory of negligence or carelessness for something that happened on February 22nd, 2015. Okay, raise your hand if you can tell me what you had for breakfast 5 days ago, let alone what you did on February 22nd, 2015. I know I can't. The second theory you're going to be sued under, most likely, is a fraud theory. Because they're going to say, you knew about conditions with respect to the property that were detrimental, and you purposefully concealed them from me. You're going to be joined with the seller when that disgruntled buyer says, I was never told by the seller or by the agent that the basement leaked, or that the roof leaked, or that everything in between was pretty much crap too. That's 2 years. If you're the agent for that party who's bringing the suit, you're most likely going to be sued under a theory of breach of contract. That's 4 years. So we're going back now to February 22nd, 2013. I don't remember February 22nd, 2013. But here's the granddaddy of them all. Pennsylvania has a consumer fraud statute, a consumer fraud act called the Unfair Trade Practices Act. And that's a law that says that if a consumer is harmed by the misleading or deceitful conduct of a vendor, of a seller, or, in your case, of an agent for a seller, the statute of limitations is 6 years. So today, we would be going back to 2011, February 22nd, 2011. there's no one here who remembers 2011 with any degree of clarity sufficient to enable you to defend yourself. But if you've got contemporaneous notes that are shoved in a file somewhere, you'd be surprised how quickly it comes back to you. And even if it doesn't come back to you, you've got something there to point to that demonstrates the correctness of your position. Create a record. That's just what I was already talking about. Make a record contemporaneous with the happening so that your disgruntled consumer, as they're called in your business, or your client, doesn't say later on, well, I talked to my agent about this and my agent said X, Y, and Z. If you've got something in your file that confirms that you gave that person some other information or some contrary information, and you've got confirmation of that in writing, you're golden. And it's important to be golden in this. And here's the reason why. When you get sued under a theory of negligence, it's a lawsuit that alleges that you somehow committed some sort of error or made some sort of mistake in the performance of your job. Look, the sun's coming out. You thought I was nuts when I said that. That's when your errors and omissions insurance kicks in and pays on your behalf. When you get sued for fraud, and they all do that, the disgruntled buyer lawsuits are always involved with fraud. There is no insurance coverage. Nor is there insurance coverage under the Unfair Trade Practices Act, the Consumer Fraud Statute, because that also, like fraud, involves an allegation that you engaged in intentional conduct. And there is no insurance coverage available for intentional conduct in Pennsylvania. It's against the law. Otherwise, you'd have insurance coverage on your car, and you'd feel that you had nothing to worry about if you decided to run your neighbor over on purpose. So you need to be mindful of those things. When there is a problem, figure out early if you're a part of the problem or part of the solution. Don't be the weatherman if you're not a weatherman. You have a license issued by the fine folks in the Commonwealth of Pennsylvania that gives you license to sell real estate on behalf of buyers and sellers, to broker or to act as an agent on behalf of a buyer or seller of real estate. You're a real estate salesperson. Your license does not give you the authority to act as an accountant, as an appraiser, as a home inspector, as a structural engineer, as a lawyer, God forbid, as a minister, or a confessor. So when your client says to you, hey, what does this crack in the basement mean? The last thing you can do is give an opinion on that, unless you're a structural engineer, which I doubt anyone in the room is. What you've got to be mindful of is that you don't invest yourself or enclose yourself in expertise that you don't have. I can't tell you how many times I've heard a buyer say, well, I thought about getting a lawyer, but I talked to my agent, and she told me I didn't need a lawyer. She does this all the time, and she knows as much as many lawyers do. Probably true. But the minute you say that, you're practicing law without a license. The minute you say that, you're giving advice to a client that's outside of the bailiwick of your expertise. So you can't hesitate. If the problem is over your head, outside your area of responsibility or outside of your control, you've got to advise that customer, that client, that consumer to go elsewhere. And you've got to help them find the right solution by directing him to the right people, not by dealing with it on your own. So, disclosure. That leads us to disclosure. When completing disclosure, first of all, everyone, if you haven't done it lately, everyone should read the seller's property disclosure statement, especially in its current form. And pay close attention to the section that you never pay attention to. I'm sure you're all familiar with the questions, and you're all familiar with the way the possible answers are laid out, especially now with the form, with the boxes on the left side and the text on the right, and the yes or no and unknown, and the explanation of all the yes answers. Forget about that part. I know you know that. Read the big part at the top. Read the fine print at the top, and read the print on the last page above the seller's signature. Because in it, you'll see two important things. The first thing you'll see is that what the seller's disclosure form is for the seller to disclose his knowledge of any material defects. What is a material defect? Who knows? Anybody? Bueller? A material defect is a condition of the property that's likely to have a significant adverse impact on its value. Okay? If I'm missing a doorstop on the bedroom closet, it's probably not a material defect. But if there's a short circuit on the light inside the closet that is traceable all the way to the fuse box or the circuit breaker box in the basement, that could very well be. However, when you read that section carefully and you read it together with the section that's just above the seller's signature, you'll see that the answers to be provided on the seller's disclosure statement are the answers of the seller and the seller alone. We used to teach people when it's time for you to give the seller the seller's disclosure statement, you want to go to the drawer where you keep the blank statements, put on your rubber gloves, take a blank seller's disclosure statement out, put it in a zip tie bag and zip it closed and deliver it like it's a piece of evidence from NCIS because you don't want your fingerprints even on that thing. But that was a bad idea because that left the seller to his own devices. If you're the agent for the seller, what you've got to do is give that thing to the seller, make sure the seller answers the questions on his own, without your help, without your input. Make sure, I would suggest, make sure you're not even around. Leave it with him, tell him you'll come back for it the next day, or he can bring it to you the next day, but do not participate in the completion of that document whatsoever. However, when you get it back, it's your job to read it very carefully to make sure of two things. This is what I believe anyway. It's your job to make sure of two things. One, make sure that every question is answered. Because invariably, it's the question whose answer is left blank that will be related to the alleged defect raised by the buyer in the lawsuit 18 months down the road. And he's going to say, you knew there was a problem in the basement with water infiltration because the question about water infiltration in the basement was left unanswered. In reality, it was left unanswered through inadvertence, but it's going to look like a smoking gun. So first job is to make sure every question is answered, and if there's a question that doesn't have an answer, you got to give that thing back to your seller and make sure he fills it in. Number two, and this is the more important aspect, I think, when you look at those answers, you want to make sure that the answers are able to be quantified. What do I mean by that? There's a difference between a subjective answer and an objective answer. When you go to the doctor says, what do you feel? And you say, well, I have a pain in my knee. That's subjective. That's coming from the patient himself. That's coming from the subject expressing what it is he feels. When the doctor says, okay, let's take an x-ray, and he takes an x-ray and he sees that there's a fracture in your knee, that's objective. That's able to be quantified. And the doctor is able to match the subjective with the objective by saying, okay, there's a good reason you have pain in your knee. You had a fracture in there. Same thing with your seller's answers on the seller's disclosure statement. You have to be careful that your seller doesn't use words that are incapable of quantification, such as, in heavy rains, there is a trickle of water down the basement wall that sometimes forms on the basement floor. Okay, where's the problem there? Number one, in heavy rains. What does that mean? What does heavy rain mean? Does heavy rain mean one of those thunderstorms that we get in August that happens between 4 and 6 o'clock at night where it rains like crazy for 10 minutes? Or does heavy rain mean a pounding rain for 2 or 3 days or a steady drizzle? What does it mean? If you can't get your seller to answer that question with greater clarity, you've got to get him to provide examples, such as the rain we had during Hurricane Sandy, such as the rain that we had during Hurricane Katrina, such as the rain that we had during whatever it was. So that's a subjective answer. You want to avoid that. During heavy rains, there's a trickle of water. What is a trickle? To some people, a trickle is just a little tiny thing, and to other people, a trickle is water pouring over the threshold of the basement window. So you've got to quantify that. You've got to ask your seller to quantify not only that, but his description of the amount of water that gathers on the floor. Is it a puddle? Is it a pool? Is it a splash pool, or is it a wading pool? Or is it a diving pool? But you've got to make sure that your seller is as accurate and as expressive as he can be with respect to quantifying that stuff. When in doubt, suggest disclosure. I can tell you, I've been doing this for 35 years or so, despite how young I look, and I've yet to represent a real estate agent or broker who's been sued for disclosing too much. It's not happened. And I get calls from agents and brokers all the time, and they say, hey, listen, I hope you have a couple minutes to talk to me. I have an issue here. I want to know if my seller needs to disclose, and I say yes. And they say, well, you don't even know what it is. And I say, the idea that you're calling me means that you're questioning it. So who's going to sue you for disclosing too much? Well, my seller doesn't want to disclose it.
We've got stigmatized properties. You don't have to disclose that.
Well, so far, you don't have to disclose it. There was just the Milliken case was decided just about 1.5 years ago. Milliken case was the one where a woman purchased a house where there had been a murder-suicide in the master bedroom. Husband had a really bad day that day and came home and killed his wife and then killed himself. And his estate, the estate of the decedents, put the property on the market, and the property was bought by real estate agents. And the real estate agents cleaned it up, painted it, redid the hardwood floors and, whatever. And after 18 months, they put it on the market, and they never disclosed that incident. And the property was sold to a single woman named Janet Milliken, who was down in Broomall in Delaware County. And Janet was she hurt herself a lot by claiming that she heard things that went bump in the night, and she swore that there were ghosts swirling around her when she was lying in the bed and all that kind of. So she sort of went she went off the deep end a little bit. She should have merely stuck with the idea that the property was stigmatized because somehow the event caused a diminution in value, but she went into all this psychological stuff. And the court, the Superior Court on appeal, ruled that a seller must disclose those things that are enumerated in the real estate seller's disclosure law, which are all those issues that are on the seller's disclosure statement. And a psychological injury or psychological damage to a property, the presence of ghosts, or the incident involved in that particular case, which was a pretty horrible incident, a murder-suicide, it's not on the seller's disclosure statement because it's not in the real estate seller's disclosure law. Therefore, the legislature must not have intended that that was something that needed to be disclosed. That's, I wouldn't bet the ranch on that being permanent. It's going to go through some twists and turns depending upon the facts of some subsequent case. But you're correct. For now, you do not have to disclose a stigmatized property. And for now, you do not have to disclose the existence of any condition that's not of the very property that you're transacting. I just got finished a case in Chester County where you know, the lawsuit comes in and there's a bunch of names on the front page. There's the plaintiff's names, and then it's versus so-and-so versus so-and-so and so-and-so and so-and-so. And I'm so used to seeing these cases that I see the first name is always the disgruntled buyer. And in this case, it was a buyer who had a bad stucco problem. Versus, you know, Mr. and Mrs. Jones, they're the sellers. My client was the agent, and my broker was the brokerage. And then there's another couple of names at the bottom. And I noticed that the name at the bottom bears an address that's right next door to the subject property. And I think to myself, wait a minute, the buyers are suing their next door neighbor? And they were indeed suing their next door neighbor under the theory that in this particular neighborhood, which was a neighborhood of $1 million homes in Chester County, the builder, the original builder, had built-in stucco issues with respect to all the properties that were so systemic that everyone knew about it, including the next door neighbor. And the next door neighbor was one of these guys who was always outside puttering around in his garden and whatnot, and saw the buyers, who were a young couple with little kids, coming to visit the property they were intending to buy, and he never told them about the stucco problem. Now, the good news is the buyer was, the next door neighbor was exonerated. He was dismissed from the case. But he was dismissed from the case 18 months after it was filed, after it cost him nearly $100,000 in attorney's fees. Okay, now, here's the.
Wouldn't that be covered under your liability insurance or your homeowners?
No, it's probably not, because the way they couched their allegations against him were in terms of fraud. There's no insurance coverage for fraud. Now,
But he didn't commit fraud.
well, he didn't commit fraud, but still, you don't have any insurance coverage for an alleged intentional act.
Yeah, but did he have a
He's
duty?
trying to get his piece of flesh back, because now that he's been dismissed and the rest of the case has been disposed of, he's now suing them to get his attorney's fees back. So they wound up winning a couple $100,000 in the lawsuit against the responsible parties, but they're going to wind up giving a big chunk of it back to him because he's going to win in the wrongful use of civil process case. Do you have a question?
Yeah, did the neighbor really have a duty to say anything?
No, and that's what the court finally ruled, that the neighbor had no duty. And that's the point that I was starting to make. You have no duty to disclose anything that's not of your property. We had one out there a couple of years ago where the disgruntled buyer sued the agents for the agents not telling the buyer that the property was within a quarter of a mile of the Limerick nuclear power plant. But if you literally walked 5 feet outside the front door, you could see the stacks. I mean, what? They're right there. What? Anyway, so let me, yes, sir.
What other type of stigmatized properties are there besides murders and things like that?
Yeah, ghost is real big. If you're in the Ninth Circuit in San Francisco, you get money if you have a ghost in your town.
Do they add value or devalue?
You've heard. I'm sure you've heard a lot about the Ninth Circuit Court of Appeals. As I had a law professor in college a long time ago who we used to read cases from the Ninth Circuit Court of Appeals, and he would say, well, you know, you have to remember what you're reading. It's from the appeals court in California, the granola state. And he referred to it as the granola state because he said, well, what wasn't nuts was fruits and flakes. Yeah. Anyway.
HIV and AIDS.
Right.
HIV and AIDS is not disclosable either.
No, it's not. If you look, I'm serious. If you look at the real estate seller's disclosure statement, those categories track. You can look up the real estate seller's disclosure law too. It's a Pennsylvania statute, and it delineates all of the issues that a seller must disclose. And if you look at the real estate seller's disclosure statement, it tracks those issues in the law almost in the same order. So whatever is on that real estate seller's disclosure statement is what needs to be disclosed. There's one thing that's not on there, but it must be disclosed elsewhere, and that is if you have knowledge of the existence or the presence of a sexual predator, a child molester, someone who's on any of the published lists. I had this issue in Luzerne County a couple of months ago where my agent client called me and said, I've got a problem. I've got this listing, and it's a home that's perfect for a young couple with kids. It's a very family-oriented neighborhood. It's a family-oriented home. There's a swing set in the backyard. It's picture perfect for a couple with children. But I just learned that the guy next door is a convicted child molester. The guy who lives directly next door. And he said, my seller refuses to let me disclose it. And I said, well, what do you want to do? He said, well, I want to disclose it. I said, well, he's telling me you can't. He said, yeah, he's telling me I can't. So what do I do? I said, you tell him you're done. It's that easy. You tell him you're done.
Doesn't the agreement of sale say that we're not responsible for that?
Well, the agreement of sale says you're not responsible for that. The agreement of sale says you're not responsible for a lot of things. The agreement of sale doesn't say that you're responsible for the stupid decisions your buyer makes. But that's not going to keep you from getting sued by that buyer when 6 months after the buyer's living there, the buyer says, I've just discovered I can't afford this property. My mortgage payments are higher than I thought they were going to be. My taxes are going up. And geez, I didn't anticipate that Johnny was going to need braces. You know, I can't afford this property, and it's all your fault. Because you sat down with me and you got out your little calculator, your little mortgage factor thing, and you told me that I could afford it, and so I did it. Believe me, I've defended 5 or 6 of those. I call them the look what you made me do cases. I think it's a category set up by my ex-wife. But I could be across the room when she dropped the pan. It was look what you made me do. Yes, sir.
You said that if goes to the lawsuit, they automatically sue for fraud as well. And you said that wasn't covered. I'm assuming the defense is covered, but if you're convicted.
Yes, the defense is covered. The indemnity is not covered. But I mean, you know, practically speaking, in your case, what they do is they'll sue you individually, but they'll also sue the brokerage. They'll sue Keller Williams, and Keller Williams can't invoke the insurance coverage, but Keller Williams would sort of come in on your behalf in that instance. The reason that they sue for fraud is because if they sue under purely negligence theory or breach of contract theory, they get their out-of-pocket damages back. If they sue for fraud, if they can establish that you were a liar and a cheater, they get punitive damages, which is a multiplier of the actual damages they get. And under the Unfair Trade Practices Act, if they can establish that you acted deceitfully or with willful deception, they can get treble damages and their attorney's fees. So they always reach for that brass ring. They don't very often get it, but it's there.
Isn't that foolish for them to sue for fraud if they don't think there's fraud there because the insurance company doesn't, the insurance company has the deep pockets?
Let me tell you what happens practically speaking. We get 6 months, 8 months into the lawsuit, and we get to the point where I now know everything there is to know about the plaintiff's case. I've seen all their documents, I've seen all their allegations on paper, and it's now time to take their deposition. And I sit down with the disgruntled buyer and I say, you understand that in count 3 of your complaint, you've alleged that my client was negligent, and in count 4, you've alleged that my client was fraudulent. And they kind of look at me funny, and I say, in other words, in count 3, you say he was careless or unintentionally committed some sort of error, but in the next count, you say he knew about the condition and he lied to you about it. That's intentional conduct. You understand the difference between unintentional conduct and intentional conduct. Not asking you to make a legal conclusion, not asking you to decide negligence or fraud or anything like that, just layman's terms, intentional or unintentional. Today's the day, as my father used to say, you pay your money and you take your pick. Which is it? Did he act intentionally or unintentionally? And they say, he acted intentionally. He knew about this and he hid it from me. And that's my story and I'm sticking to it. And I go on to something else. And a couple minutes later, I sometimes come back to the same issue. And I say, I just want to clarify, you're still of the opinion that given the fact that my client arranged a home inspection for you, he arranged protection in the agreement of sale to allow you to bail if you didn't get a mortgage. He got your radon inspection. He got your termite inspection. He let you get into the property 3 or 4 times to take a look at it stem to stern. You think this is a guy who committed fraud? He opened the doors wide open for you to see the whole thing, and you still think he committed fraud? Yeah, he committed fraud. He committed fraud. Okay, this would be a good time to take a break. And we take a break, and we go outside, and I grab his lawyer in the hallway, and I say, what are you doing? And they all look at me like I'm speaking Chinese. And they say, what do you mean? I say, I just gave your client 16 opportunities to say negligence, and he says fraud. He says, well, your guy committed fraud. I said, you understand? You're killing the insurance coverage. So you win your case the way you're making it out, there's no one there to pay you. Oh my God, I never thought of that. I say, well, you better think about it. So I'm going to go to the men's room, and when I come back in 5 minutes, we're going to resume, and I'm going to ask your client the question again. And you won't believe how quickly the answer changes. It happens all the time. So let me not take up too much more time. I want to move on to a couple of things that sort of dovetail with what I've been talking about so far. There are 2 more pages on this handout that bring me to the 2 specific issues that I discussed with Debbie yesterday that I would be touching on. First is dual agency. And I give a version of this lecture from time to time that I call the perfect storm of real estate situations. You know, the story, The Perfect Storm, the book was made into a movie. The Perfect Storm was a combination of 3 different weather systems that converged at the same time to create the perfect storm. I'm telling you the story because I've had this actual case twice in the past 2 years. And in each case, it marked the highest amount of money my clients have ever paid to get out of a problem. well into six figures. The perfect storm is this: dual agency, stucco, and prior buyer. And by that I mean, in this particular instance that I'll tell you about, my client was the agent for the seller who had a $1.2 million home clad mostly in stucco. Buyer number one comes along, represented by an outside agent from a different brokerage. Buyer has a home inspection. The home inspector says, "I'm not feeling too good about the stucco. I think you should have a moisture intrusion inspection." The buyer has a moisture intrusion inspection and it fails. Buyer bails out of the deal. Property stays on the market. A couple months later, second buyer walks into listing agent's office and says, "I want to talk to listing agent so-and-so about property such and such." So she meets with the folks, she takes them over. They don't have an agent of their own. She signs them up. She's going to be a dual agent. They have a home inspection. The home inspector for a new buyer says, "You know, I don't know a lot about stucco, so I can't really give you an opinion on the quality of the stucco on this place. So, you know, you might want to talk to an expert." The buyer says, after the home inspector leaves, he has a conversation with his agent, who is, remember, also the agent for the seller, and says, "What about a stucco inspection?" And she says, "Well, your home inspector didn't think you needed it. I heard what he said, and if you wanted to have it, you could have it, but it costs $7,000, and you know, it usually turns up nothing. And I don't know about any condition in this neighborhood that would cause you to want to have that." And so, of course, he is dissuaded from having the moisture intrusion inspection. Instead, he buys the house, he moves in. 6 months later, there's a fire in the kitchen. And the firemen rip out the cabinets and the drywall behind the stove, and it's on the back wall of the house. And when they rip out the drywall, they realize that what's going on behind the drywall is a virtual science project. It cost them $425,000 to fix the house. And a good part of that was unfortunately funded by my client. She denied, by the way, that she ever told him a stucco inspection was $7,000. She denied that she dissuaded him from having it. But when he asked her about what happened to the first buyer, I understand the place was under contract before, she reportedly said,